Hello everyone, welcome. I am Sahil Bansal, and in this series we are discussing Code of Civil Procedure 1908 with a focus on clarity, structure and a close reading of the text. So today in the first session we'll be discussing what is the layout of the Code of Civil Procedure. Henceforth we'll be calling it CPC for ease of discussion. We'll see what is the layout of it, what does it consist of, how has it been divided, so that you start getting a little familiar with the text of the BEAR Act, the layout of the BEAR Act, and the way it is structured so that it starts feeling less alien to you. And as I said in my introductory session, please keep a copy of the BEAR Act handy so you can always refer to it whenever we are discussing the provisions or we're referring to some part of it, so that the more you open it, the more you have touch and feel of the pages, less alien it's going to start feel to you whenever you're using it in your work or maybe in your studies, because a very big task of reading the law is to get past the fear of opening a very clean BEAR Act which does not feel yours. So let's make it yours while we are progressing slowly, so that when you mark it, when you write your annotations in the margins, you start getting a sense of the BEAR Act to be your own, and when you read it, you don't feel distance from it. So in today's session, we will first begin by looking at what is CPC, when did it come about, was it preceded by somebody, who wrote it, what was the need of writing it, what is the nomenclature, how has it been divided into different parts, and how those parts operate with each other. Then we will move on to get a layout of the discussions that we'll be having in the course of this series in different sessions. I will lay out the different topics that we will discuss. We will lay out certain core topics, and then we'll actually divide the topics in concentric circle of sorts. So at the core will be certain topics which will be discussed regularly, and then there'll be the next concentric circle from which we will pick up topics to weave into those core topics as we progress. Then from the outer concentric circle, we will pick on further topics which will keep coming and going, and that's how we will complete the whole CPC. We will not necessarily move in the order in which the sections and the orders and the rules are written in the text, but we will proceed in a more logical way that will make a little more sense to you as to why do we have a certain provision in the CPC. So my plan is to progress based on how a civil suit. I'm not going to use very big terms at the very start of this series so that you feel more relatable. I will start to introduce more technical terms for very basic things. Law is nothing but very technical and formalized terms for very simple procedures that govern human relations. So if you have civil case is the general parlance, but in CPC you will call it a civil suit. So we will progress our discussions based on how a civil suit progresses. I will tell you the trajectory of a civil suit, exactly from where does a civil suit, a civil case begins and where does it end. We will make that timeline, and then that will be a skeletal structure in which we will be carrying on our sessions, and we will keep feeding new topics to each part of that skeletal structure. So for example, when we will discuss how does a civil suit begin, then we will discuss what is cause of action, what is the next step after that, and at that next step I'll tell you what all topics we will discuss. Do not be scared. Today is all about introduction. We will spend ample amounts of time on introducing this legislation so that you're familiar with it. So when we progress into a detailed reading of a provision or a topic, you already know that what is the basic idea behind it and why are we reading it and at what stage of our discussion we are at, so that you don't feel left out or you don't feel taken by surprise. Today is all about that. Today is all about bursting any sort of fears or myths that you might have about CPC, that it's inherently difficult or something. It's not. It's not. Trust me, I was in your position at one point, but the more I have engaged with the law, I've realized it's literally nothing. It's everyday stuff put into formalized terms, so that law has its own castle which you cannot breach very easily, and that castle is only built upon formalization of things, nothing else. Once you understand the basic idea, it's very simple. It's just fancy terms being used for very basic procedures and basic things that govern human relations. For example, if A does something wrong to B, B will go to the court. What is this A doing something wrong to B mean? It means a civil wrong has happened. You call it a civil wrong, or you call that A did a wrong against me. You add the word civil and it becomes formalized. That's all what the law is about, but I will not go into that yet. We'll progress slowly. Once I've given you the skeletal structure, I will tell you the topics that we'll be discussing. I'll also try to tell you the provision numbers, just in case you would like to note it down next to the skeletal structure as you are writing it down or taking down notes, so that when we come back to it in the further sessions, it takes you back. Your mind rings up that, oh, this was mentioned in the first session. That's how you stay connected with the law. These small things, they get stored at the back of your memory, and when you again encounter them in your discussions, you don't feel alienated. You feel seen. You feel as if you know something about it already, and that's the beauty of it. Once that starts happening, you just start loving the law because it's not unfamiliar to you anymore. So let's begin. CPC, what is CPC? CPC is, I'll tell you first who wrote it. It was written by Sir Henry Earl Richard, and it's not the first law in India that governed civil procedure. What is civil procedure? Civil procedure is very simply a procedure in which the civil case proceeds. The need for having a civil procedure written down was to have a uniform one. For every person's case, there cannot be different procedure. We will never see the end of litigation if every case has its own procedure. That is why we needed a one uniform procedure to carry on civil cases. Civil cases are essentially cases that are arising out of civil wrongs. So we have criminal side of the law, we have the civil side of the law. So criminal side is about the offenses. You have murder, you have robbery, you have theft. All of that is criminal. In the civil side, you have civil wrongs. These are also wrongs which are done against you, but they're civil in nature. For example, two people enter into a contract. One person is performing his part of the contract, but the other refuses to do so. Now that can be an offense in the criminal terms, and it is a civil wrong. In the sense of civil wrong, it will become a breach of contract. Simple English, breach of contract. There was a contract between two people. One of them has broken it. He has breached it. So we're calling it breach of contract. Now, once that has happened, the remedy that this person who has been harmed by such breach of contract by the other party will need a remedy. How does he get that remedy? Will he go loot the house of the person who has breached the contract? No. That will be an offense in itself. No. The way to claim these remedies is to go to the courts. And courts will then start a civil case, as we call it, in order to give this person their remedy. Now, what will be the procedure in which the civil case will proceed is given in Code of Civil Procedure. Literally, the name says that. CPC was drafted by Sir Henry Earl Richard, and it was preceded by CPC which existed since 1882. So the CPC that we are reading now was enacted in 1908. And it came into effect on 1st of January 1909. The enactment happened on 21st of March 1908. Before the CPC of 1908, we had the CPC of 1882. Now, let's take a look at how the CPC has been divided, how the procedure has been divided, how it has actually been put into readable terms. So, the CPC of 1882, it had about 652 sections and there were 49 chapters. So essentially, like any other law, it had sections which were divided into chapters. Chapters, what would the chapters do? They were divided by the topic. So you have one topic, then you have all the sections related to it. You have one chapter, you have all the sections related to it. But now, for the ease of reading and to have it more structured, we have sections, we have orders, and those orders contain rules. So people get scared hearing all these terms, but it's just nomenclature. It's just the change of nomenclature. Whatever was contained previously in the 1882 CPC in those 652 sections has now been divided in a different way. Now you have 158 sections and you have orders and rules. So for usually how it operates is that you will have a section dealing with a particular topic. For example, summon is basically summons is a document which is sent to a particular party who is required to appear in the courtroom. So you have summons. So there will be a section in the CPC, a section that will deal with summons. But that section will not be comprehensive enough. It will not tell you everything about the summons. Maybe it will tell you when the summons are supposed to be sent, or how soon should you send the summons, or how do you send the summons? Do you send it by post? How do you send it? That section might tell you a little bit about it, but you don't have all the information. And we cannot leave room for interpretation, a very wide room for interpretation in the law, because then everybody will have their own interpretations and it will go haywire. Now, while that section tells you a limited amount of information about a topic, you will have a corresponding order. Let's open the index of CPC. If you see here, you have sections. These are your sections. And the sections part are divided into parts. So you have 12 parts. First part being preliminary. Then you have part 1. Please look at the index. You have part 1. As you progress, you have part 2, you have part 3, and it goes all the way up to part 11. So preliminary part plus 11 parts, you have